So talk more about exactly what the court ruled today.
Well, Anderson, what this appeals court said is that Evan Corcoran, Donald Trump's attorney, is going to have to go back before the grand jury. He's going to have to provide additional testimony that's slated currently for Friday. And he's also going to have to hand over documents to prosecutors. And we're learning those documents include things like handwritten notes as well as transcriptions of audio recordings. And this comes after a lower court judge decided that prosecutors presented enough evidence before her to show that Donald Trump may have committed a crime and he may have used his attorney to do that. And because of that, that sort of pierces the attorney-client privilege. It means that no longer stands. Corcoran has to answer more questions, and the appeals court upheld that decision. Now, Trump's spokesperson, as you said, is weighing in on this evening, saying there is no factual or legal basis or substance to any case against President Trump. The real story here is that prosecutors only attack lawyers when they have no case whatsoever.
Can you just remind viewers of the role that Evan Corcoran has played in the classified documents saga?
Yeah, I mean, he's really a critical witness for prosecutors because he was sort of in the thick of all of this. I mean, remember last spring when Donald Trump got this subpoena to hand over any remaining documents at Mar-a-Lago with classification markings on it? Well, Evan Corcoran was one of the people who was involved in that search for documents. He was involved in crafting the statement they later provided to the government saying, we've done this diligent search, you know, the one Christina Bobb signed, and these are all the classified documents that we can find. And then remember, we learned, of course, when the FBI showed up and searched Mar-a-Lago that wasn't accurate. There were plenty of other documents floating around with classification markings. So in January of this year, Evan Corcoran goes before the grand jury. He does his preliminary testimony, refuses to answer a bunch of questions, and that sort of gets us to where we are now with this flurry of legal motions before these courts, and ultimately this decision by the appeals court that he has to go back in.
Sir Murray, I appreciate it. I want to get some perspective now from CNN contributor John Dean, who served as White House counsel in the Nixon administration and is certainly familiar with presidents facing legal jeopardy, also Harvard Law School senior lecturer and former federal judge Nancy Gertner. John, how big a deal is this ruling from the federal court in Washington?
I think it's a big deal. It's a big deal because this, contrary to Trump's take, he could be a remarkable witness with documents to corroborate his own statements. Apparently, he made contemporaneous notes that he dictated and then later transcribed them. So this is a real serious ruling, and the exception to the crime fraud rule shows that the judge thinks there's probable cause there is a crime here.
Yeah, I mean, Judge Gertner, can you just explain how rare it is for a judge to actually allow prosecutors to pierce the attorney-client privilege and the high bar that prosecutors have to clear for that to happen?
Well, in 17 years on the bench, I don't remember ever finding that the crime fraud exception had been met.
Wow, really?
So
Wow.
I mean, the notion, the privilege is a very significant privilege in the law, and so the notion that you set it aside if you believe that the client is using the privilege not to get legal advice but to hide something. And since the key to the Mar-a-Lago case is whether Trump willfully retained classified documents, this kind of testimony could be very important. If the lawyer essentially was told by Trump, don't worry, I'll take care of it, and then drafted a document that said we'd done a diligent search when he hadn't, and he was in touch with Trump to the opposite effect, then it could have some significance here. But it's very unusual.
Judge Gertner, just to be clear, I mean, the court rulings in Washington, correct me if I'm wrong, it means that multiple judges concur with the Department of Justice that they have evidence the former president used his attorney in the furtherance of a crime. And is there any other interpretation of this?
No, not only that, the speed with which they operated suggests that there really wasn't an issue here, right? So Judge Howell issued the decision. She said that the government said they wanted to appeal. She said a briefing schedule, the Court of Appeals rather, set a briefing schedule that was a matter of hours, and they issued their decision a matter of hours later. I mean, it suggested that there is no there on the former president's side. That is extraordinary in itself.
And John, if prosecutors have compelling evidence that the former president used his attorney in furtherance of a crime, what part of the investigation do you think that would likely involve? Would you expect it to be the obstruction piece?
It's hard to tell. As the judge suggested, it could show his intent to willfully keep these documents contrary to the statute that forces him to return them. They are classified, and there are all sets of rules that govern classified documents, and the government is very aggressive in going after this kind of information. I don't think the government is comfortable that Trump indeed has turned over everything he might have So that's probably giving them impetus to move quickly rather than slowly on this case.
Judge, it's not only that Corcoran's expected to testify, he's also being asked to turn over documents, including handwritten, transcribed verbal notes regarding his representation of the former president. What kind of evidence might prosecutors be looking for there? I mean, what's the advantage of that?
It would show what Trump knew. Whether, when the search took place initially, people wanted to characterize the documents at Mar-a-Lago as maybe it was a whoops, like the Pence documents, the documents that had been found in Vice President Pence's house, or the documents found in President Biden, then Vice President Biden's house. That was like, maybe it was an inadvertence. This is going to be testimony that suggests that it was intentional. And the intentional retention of these documents is key to the crime.
Nancy Gertner, John Dean, I appreciate it. Thank you. As John Dean himself knows, his former boss was the gold standard, if you can call it that, for presidents accused of serious crimes. He's only one of two who've even come close to being indicted. The other, of course, Bill Clinton. More on both now from CNN's Randy Kay.
5 people have been arrested and charged with breaking into the headquarters of the Democratic National Committee in the middle of the night.
June 17, 1972, a break-in at the Watergate building. President Richard Nixon denied any involvement.
I first learned from news reports of the Watergate break-in.
Still, at hearings held by the Senate Watergate Committee, witnesses testified about the voice-activated taping system in the Oval Office. On those secret recordings, Richard Nixon can be heard talking about the Watergate break-in.
When were those devices placed in the Oval Office?
Approximately the summer of 1970.
Nixon invoked executive privilege and refused to give up the tapes to the special prosecutor until the Supreme Court forced him to.
Play it, that's the way they play it. That's the way we're going to play it.
Nixon knew he was going to be indicted if he stayed in the White House. The wolves were barking at his den.
In fact, this document, released in 2018 by the National Archives, is the grand jury's draft indictment, dated February 1, 1974. It shows they plan to charge Nixon with several crimes, including obstruction of justice. Ultimately, Nixon was named as an unindicted co-conspirator. And after the House Judiciary Committee passed 3 articles of impeachment against Nixon, he resigned in disgrace. The full House never voted on the articles of impeachment.
I shall resign the presidency effective at noon tomorrow.
His successor, President Gerald Ford, pardoned him, and Nixon was never indicted. More than 20 years later, another president was staring down an indictment.
I did not have sexual relations with that woman, Miss Lewinsky.
That was President Bill Clinton in January 1998, denying he had an affair with then White House intern Monica Lewinsky. That same month, he denied it again under oath during a deposition in a sexual harassment case brought against him by a woman named Paula Jones. Months later, he reversed course.
In a deposition in January, I was asked questions about my relationship with Monica Lewinsky. While my answers were legally accurate, I did not volunteer information. Indeed, I did have a relationship with Miss Lewinsky that was not appropriate.
Clinton had perjured himself during that earlier deposition by falsely claiming he hadn't had sexual relations with Lewinsky. Lying under oath during a deposition is a felony.
There was a very great drumbeat for him to have criminal charges not just pressed against him, but to have him arrested for lying to the federal government, for perjuring himself.
Months later, during his grand jury testimony, Clinton explained whatever happened with Lewinsky, in his eyes, was not sexual relations.
They did not constitute sexual relations as I understood that term to be defined at my January 17, 1998 deposition. But they did involve inappropriate, intimate contact.
By then, the damage was done. Still, Clinton avoided indictment by admitting in an agreement with the independent counsel that he gave false testimony under oath.
There was a whole slew of agreements that Clinton made just to kind of clean the air and to allow himself to have a noble post-presidency.
Randy Kay, CNN.